The George Zimmerman trial is underway in Florida. Opening arguments started off with cursing and a really bad joke. We're joined by WGY legal analyst Chas Farcher of Martin, Harding & Mazzotti. Good morning, Chas.
Morning, Kelly.
So that's a pretty risky move here on both sides. One started with the F word, the other started with a knock-knock joke.
Yeah,
Really?
I think so.
Have
Yeah,
you-
well, I think so.
Did you ever start with a knock-knock joke in opening arguments before?
I haven't. And here's the thing, too, is I think it was actually a good joke. It's just the wrong forum. Opening argument is the attorney's first chance to really connect with the jury, make promises in terms of what they think the evidence is going to show. And then, the jury expects you to keep those promises and deliver on them. I understand what defense counsel was trying to do. The jury process, the jury selection process took 2 full weeks. These 6 women went through that entire process. So it was an attempt to connect with them early on and score some points and try and build that relationship. Unfortunately, I think it's the wrong forum. You have one family who's lost a young boy, and you have another man who's on trial for his life. I think you've got to read those jurors. And hindsight's 20/20, but you've got 6 women, some of which who came dressed in entire suits. They were obviously taking the situation very seriously, as they should have. So maybe a joke was the wrong approach initially.
Yeah, I just don't know. I know he's trying to connect with them. I just don't understand the point. I mean, nothing about the case, so you're on the jury. I mean, what was his ultimate point? I don't quite get it.
Well, like I said, in my mind, it was an initial attempt to try and connect with them and set that at ease. You got to understand, too, it came in the context of a very serious opening, by the district attorney before. So I think he was trying to paint some contrast there and show that, listen, it's a tough case, but, put them at ease a little bit and get into their minds early on. I just don't think it worked out nearly as well as he would have hoped. If he could do it again, I don't think he would.
Yeah, it seemed a little flip for the nature of what he was there to do.
Right.
But in terms of the F-bomb and on the other side, that's just as risky because that's the first thing people are going to hear.
Yeah, you know what? It's a great way to get the jurors' attention. I mean, if you heard that opening argument for the first time, if you watched it, if nothing else, you immediately began to pay attention. So it was a way to immediately open the jurors' eyes and ears and get them to pay attention to exactly what you were doing. And I think what the district attorney's trying to do is, completely on the other end of the spectrum, explain and show what a very serious thing this is, what a very serious case this is, and also paint a picture of George Zimmerman first thing right out of the gate.
Yeah, you know what? Yeah, I don't know how these 6 women received that, but I do think it does point to it was very evocative in trying to prove that Zimmerman was an angry man.
That's exactly right.
Yeah.
The defense here is going to be that Zimmerman, acted in self-defense, that Trayvon Martin was the aggressor, and when you come right out of the gate with words like that, with that profanity, you paint a different picture of not this innocent guy patrolling the street trying to keep his community safe, but really someone who had some malice in his heart. And I think that's what the district attorney was trying to do there.
I don't know how much you've seen of the evidence, but this 911 call where somebody is screaming in the background, there's been a lot of talk about this. This will be key, and the jury will try to determine who's screaming, if it was Zimmerman or Martin. Do you think that's a key bit of evidence, or is that overblown a little bit?
No, I do think it's a key piece of evidence, and I think not being able to have experts testify as the prosecution would have liked, I think it's a blow to their case. If they could get an expert up on the stand to say there's no way this is George Zimmerman screaming for help in the background, this is a young boy, I think it deals a significant blow to, again, his self-defense claim. But now what you're going to have to do is you're not most likely, you may have to put Trayvon Martin's mother up there to say, that's my son, I recognize that voice, or put Zimmerman's wife up there and say, that's my husband, I recognize that voice. If Zimmerman's screaming for help, it certainly paints a better picture of him actually acting in self-defense. If it's a young boy screaming for help, it makes self-defense a difficult claim. So I think it is a key piece of evidence, and now the jury's kind of got to come to their own conclusions without the assistance of any experts.
But not having those experts testify, would that be enough to provide reasonable doubt if you can't determine who it is?
Not necessarily. The defense is certainly going to rely on that and say, listen, here, this is Zimmerman screaming for help, but the prosecution's going to say, no, this is Trayvon Martin screaming for help. And, the jury, they're the finders of fact. They have to come to that conclusion, and they can make that decision. Or they can make no decision and say, listen, we really can't tell who it is screaming for help, but based upon all the other evidence, we could still exclude reasonable doubt. It depends upon how the proof is put in.
Well, the trial's expected to last about 3 weeks, so we'll be checking in with you quite often over the next 3 weeks. Chas Farcher of Martin, Harding & Mazzotti, thank you so much.
Have a good day, guys.
Yeah, you too. Thanks, Chas.